Hello students. In today's lecture, I'll discuss about the subsequent segment on wildlife protection and the law which we started in the previous lecture. Now, when it comes to this Wildlife Protection Act, which we already started discussing, we dealt with some of the crucial definitions and some of the crucial authorities which were created by the Wildlife Protection Act of 1972. And in addition to that, we have also referred to some of the important provisions relating to the same legislation and a reference to the international conventions on wildlife protection. Now, and of course, to be very specific, the definition of wildlife, which is there under Section 2, subsection 37 of the Wildlife Protection Act, which is very inclusive in nature. Now, moving on to the other segments of the wildlife protection and the law, we'll discuss some other provisions and relevant case laws relating to that and offenses and penalties under the said legislation. Now, one of the important features of the Wildlife Protection Act is this concept of protection, the protected areas. Now, when you say this word protected areas, you must be wondering what exactly it is all about. Well, in general connotation, this particular protected areas, which we usually use in our day-to-day life as national parks and wildlife sanctuaries, species-specific reserves, etc., etc. Now, these national parks and sanctuaries are basically the conservation reserve. Now, in order to protect certain specific species which are very much critically endangered, the Wildlife Protection Act, in fact, takes a very ecocentric approach, and all thanks to the Honorable Apex Court of our country, which has from time to time pointed out that there is a dire need and urgency, in fact, to protect and preserve several such critically endangered and vulnerable species. And that is the reason because of which we have seen an amendment which in fact came in the year 1981, which in fact, and of course subsequently in 2002, which incorporated several such provisions in the Wildlife Protection Act. And when it comes to this particular critically endangered species, Section 36A is very relevant in a way. But on the top of that, when it comes to identification of protected areas, you have to refer to Section 18 of the Wildlife Protection Act, which in fact clearly enunciates that the state government may by notification declare its intention to constitute an area other than an area comprising any reserve forest or territorial waters as a sanctuary if it considers that such area is of adequate ecological, faunal, floral, geomorphological, natural or zoological significance. And this is something which, in fact, has been taken forward also under the Wildlife Protection Amendment Act of 2002. Now, if you remember, this concept of which I'm talking about, this protected areas and this national parks and sanctuaries, which are also known as conservation reserves, are basically for not just protecting the wildlife but also their habitats, right? Which includes the landscape, the seascape, flora, fauna, etc., etc. Now, this concept of protected areas within itself covers the conservation reserves, and in addition to that, it also covers something called community reserve. I'll come to that. However, prior to that, I would like to mention some of the important case laws, which in fact change the entire scheme of this Wildlife Protection Act. Now, in order to do that, I would like to highlight a particular case law from Center for Environmental Law (WWF) versus Union of India, where this species-specific interest standards was pretty much invoked, and that was with respect to safeguarding a particular species of Asiatic lion. And in fact, in that particular case, the Honorable Apex Court clearly held that, and when I'm saying the case, that is the Center for Environmental Law Worldwide Fund India, that is WWF India versus Union of India, where in order to safeguard this species of Asiatic lion, the Apex Court declared that they have a right to live like human beings. And this Asiatic lion has been identified as an endangered species. In addition to that, it has also declared, the Apex Court also declared that The wild water buffalo, they are also another endangered species which has been identified as endangered by IUCN, the International Union for Conservation and Nature. So the apex court directed the state government to give from time to time effectfully the centrally sponsored integrated development program for wildlife habitat scheme. Now this integrated development, you will also come across that particular integrated development program of wildlife habitat scheme 2009 subsequently in this lecture. But this scheme was a centrally sponsored scheme, and the objective of the scheme was to safeguard several such endangered species. And in fact, this is not the first time when the was WWF case. In fact, even in TN Godavarman Thirupal versus Union of India, this is from the same area. Of course, this is from 2012. Even in that case, the court observed the issues of man-animal conflict, and where human encroached animals also encroached human territories. So the court in fact adopted a very different approach, and it kind of deviated from its anthropocentric approach, and it took a very egocentric approach in the Godavarman case. And it identified that there are several such critical, endangered, and vulnerable animal and rare species which needs to be protected and preserved. And in order to do so, the Supreme Court, in fact, reiterated that there should be a very stringent measures from the side of the state governments as well as the central government to ensure that this increasing human activities and unprecedented over exploitation of natural resources shouldn't happen, because they are the one which is responsible for they are a threat, in fact, to the rare species of flora and fauna and several other critically endangered species and their respective habitats. So this is something which you should keep in mind. The once the Center for Environmental Law case, and which is with respect to Asiatic lion and wildlife buffalo, and same with the T and Godavarman's case. Now, this is the thing is that when it comes to this protected area, this concept of protected area, as I was speaking, in fact, this is up to the state government to declare a particular area as protected area, and in order to do so, the collector of a particular district will definitely have to take care of the species. You have to take care of the habitat, but in order to do that, you have to ensure, when I'm saying you, I mean the state government or the central government, you have to ensure proper boundary, and within that boundary all the actions or so-called human activities should be refrained, should be prohibited. So in order to do that, these district collectors, they shall inquire into and determine the existence, nature, extent of any such rights which is there in that existing land which the government intend to declare as a protected area. So if a state government wish to declare a particular hectare of area as protected area by a notification, it can do so under section 18. It has to kind of declare its intention to constitute that area, and as I've already mentioned, but such declaration should aim to protect the wildlife, should aim to protect the forests, and such notification should be very specific, highlighting the situations, the limits of that area, by roads or bridges or any other intelligible boundaries which is required to be mentioned in there. But in order to do that, the district collector is the one which shall enable the state government to take such decision. And in order to do that, the district collector will also inquire whether there is some people residing in that area, whether they have any rights involved in with respect to particular land which is coming under that proposed area which the state government wish to declare as a protected area, be it a sanctuary, of course, in this case. So after that notification, which comes under section 18, is issued, there is a period, there's a timeline which they have specified, and this within that limitation period, all these claims needs to be addressed, and the district letter plays a very pivotal role as regards the same. In addition to that, there is another provision which of course is relevant with respect to that, but prior to that, you should also keep in mind that once the state government issues this notification specifying the limits, declaring a particular area as sanctuary for a specified date, no such alteration of the boundaries of sanctuary shall be made except a resolution that is passed by the state legislature. So once it has been declared by notification by the state government, if you want to alter, if you want to extend it or reduce it, any such alteration can be done only after the resolution passed by the state legislature. In addition to that, section 18A is relevant, because section 18A, in fact, which is also which was also referred in TN Godavarman Thirumul Pars versus Union of India 2012 case, because this particular section empowers the state government to declare its intention to constitute any area other than an area comprised within any reserve forest or territorial waters as sanctuary. And if it considers to do so, any such reserve should be of adequate ecological, faunal, floral, etc., significance. But in order to protect, propagate, and develop the wildlife of the environment, this is the objective which has been enshrined. So this is something which has been also mentioned under section 18A. So any area other than the area which comprised with. So if so, difference between section 18 and section 18A is that under section 18, the state government can only consider the reserve forest or a territorial waters to be declared as a sanctuary, keeping that ecocentric approach. But if the state government wants to declare any other area which is not a reserve forest or territorial water, because it comes under their jurisdiction, right? If you remember the Forest Act of 1927, I did mention about reserve forest, protected forest, village forest, non-counted forest, and reserve forest was very much, where any kind of activities, human activities, strictly prohibited. So, if at any area which is not a reserve forest or territorial water, then Section 18A will be invoked by the state government to declare it as a sanctuary. And these limits of the sanctuary can be reduced by the state government. That was also held in the Consumer Education and Research Society versus Union of India. It was clearly held by the Honorable Apex Court that the legislature, they have the right to reduce the area by issuing a notification, but such reduction in that area by the legislature cannot be invalidated even when it is taken in haste and without considering all aspects. But unless there is a material to show that it will be irreversible cause and irreversible and adverse effect on that wildlife environment, then in that case only such decision can be revoked. But otherwise it isn't. This was with respect to this Chinkara sanctuary. There is the Narayan Sarovar Chinkara sanctuary. And in this case, the Gujarat legislature had reduced the area of Narayan Sarovar Chinkara Sanctuary from 765 square kilometer to only 442 square kilometer by notification. And this notification was challenged by the court. The court upheld the reduction notification of the state government, and in fact, this is something which is very crucial because there are several such judgments where you will find that even the apex court and other courts of law, they have tried their best to balance the development and environment. That is something where, from if you look at everything from the lens of ecological or ecocentric approach, you might not get that happy if you refer to some of these judgments where such things have been taken with keeping this aspect of revenue development and welfare on one side and environment protection on the other side. Now, in addition to that, the Chief Wildlife Warden, which is also one of the enforcement machineries under the Wildlife Protection Act that I have mentioned, please to refer to Section 27 and 28 of the Wildlife Protection Act, because these provisions kind of deals with the powers of the Chief Wildlife Warden. And in fact, the Wildlife Warden may, on application, grant to any person a permit to enter and reside in a sanctuary. But for doing that, what are the criteria that they have to take into consideration? Of course, the Chief Wildlife Warden will only give or grant such permit if it is for, say, investigation purpose, study of a wildlife, or photography, scientific research, tourism, transaction, or even any public servant who is in official duty, or if it's a permit holder or a person having a right over certain immovable property which comes within the limit of the sanctuary. Only these are the people who can get, or these are the reasons because of which you can get a permit to enter this so-called protected areas only after the approval of the Chief Wildlife Warden as per Section 27 and 28 of Wildlife Protection Act. In fact, with respect to living inside a wildlife area, there was a Gujarat High Court judgment, Mahesh Kumar Trivedi versus State of Gujarat. In this Mahesh Kumar Trivedi versus State of Gujarat, the Gujarat High Court in fact clearly held that no one has a right to enter or even possess a particular land in a sanctuary except under the permit which is granted by the Chief Wildlife Warden under Section 27 and 28. So the Chief Wildlife Warden has immense power, the permit granting power, and without that power, in fact, no one can even live inside a wildlife area. That is what is held. In this particular case, it was with respect to rehabilitation of some Pakistani nationals who crossed over to India in 1971, and Later on, they were they were deciding a particular area which was declared as a wildlife sanctuary for a particular species in 2001, and this entire matter came in front of the court of law, and it was held that, of course, only with the permission of the chief wildlife warden, an individual can live in a wildlife area. There are several such other relevant cases with respect to wildlife protection. Uh, this is an inclusive list. There are several other case laws. You will find it across several other research databases. For example, this Kamla Khan Pandey versus Prabhagya One Adhikari Opra. In this particular case, this is kind of from 2005. It was with respect to Section 29 of the Wildlife Protection Act, because under that, the state, in fact, is empowered to stop any mining activity on operation in a protected area. It can, in fact, go ahead and terminate a lease which has been granted to any authority or an entity, private entity, for covering certain conducting certain mining activities. But such power to cancel the lease is very quasi-judicial in nature, and it's not merely an administrative power. No, in this case, what happened that the mining lease was granted under the Mines and Minerals Regulation and Development Act of 1957, and it was something which was also clashing with the wildlife. So the permission of wildlife authorities is something which is must. So in addition to the MMDR Act of 1957, in order to go ahead with any mining operation in a protected area, the permission of the chief wildlife warden is must. It was held in the Kamla Kant Pandey versus Prabhagyavan Adhikari Ubra. Kamalakant Pandey, they have another case. This is again state of UP. I haven't mentioned here. In that same case, it was also with respect to lease money, which was a matter of wildlife sanctuary area. In fact, in UP, and the permit holder was prohibited from setting fire in a sanctuary and entering with a weapon, except with the prior permission of chief wildlife warden. So this is what it was. In fact, this is a case which kind of invoked Section 32 of the Wildlife Protection Act at the same point of time. In addition to that, the SR Oil Limited case versus Halar Utkarsh Samiti. Now, this was with respect to application of Section 29 and its scope. In fact, it was declared that if anyone wish to carry on any such activity, you have to get the license, right? But before granting license, the state government must also ask that particular private entity or the project proponent to undergo environment impact assessment notification compliance. So the thing is that that individual or the project proponent, they have to obtain EIA certificate, EIA permission from the expert bodies. Under EIA notification, you have EAC, an appraisal committee, and you also have a state levels state environment impact assessment authority. So there is a procedure for that as per the EIA notification. And now, in addition to the lease that is you get it from the government, you have to also get EIA permit from the prescribed authority under the EIA notification, accompanied with the EI management plan, the environment management plan, sorry, not EI management plan, environment management plan. And all these things should be taken into consideration, and only on the basis of that, the state will permit the particular entity. And in this case, it was the SR Oil who wanted to lay down certain pipelines inside the Jamnagar National Park and Sanctuary. So this is what it was held, and Section 29 was pretty much invoked in this particular case of SR Oil Limited versus Halar Utkarsh Samiti. Similarly, several such other case laws, in fact, came in front of the apex court from time to time and high courts from time to time. There was another case where it was with respect to the Chinkara Sanctuary case only. This Narayan Sarovar Chinkara Sanctuary, which I mentioned a while back. Now, in this particular case, there was a matter. The state government of Gujarat, it declared a particular area, as I mentioned, as Narayan Sarovar Chinkara Sanctuary, which was around 765 square miles, and it was done under Section 18 of the Wildlife Protection Act. But later on, by passing a resolution, it reduced it further to a 442 square kilometer and designated an area of 321 square kilometer, which was pretty much rich in lignite, bauxite, limestones, etc. Now, this was done as per the law, which is there under Section 26A of the Wildlife Protection Act, and this resolution, in fact, also came into effect. So thereafter, what happened is that petitioner was pretty much apprehensive about that, and that they filed a writ petition challenging this particular notification of reduction of the Narayan Sarovar Chinkara Sanctuary. However, this High Court, in fact, dismissed the writ petition, stating that this particular area, which is already there with the wildlife sanctuary, which is 444 square kilometers, it is sufficient for the protection of the chinkaras of this particular area, and it is also sufficient enough for the vegetation and the wildlife to grow. So and at the same point of time, the mining activity will definitely be helpful for the people who are residing in Kutch. So if proper conditions are laid down, then the state can go ahead and mine and start with all these developmental activities, which is in fact cement plants and all, which are required for such things. But the apprehension was still there because the cement plants and all, they were adequate enough to cause certain pollutions. But the judgment went against the petitioner's contention. So he went to the apex court, and the apex court, in fact, reiterated. Apex court, in fact, it was pleaded by the state government that this particular theory which was put up by the petitioner is pretty much flawed, because the objective is, of course, to protect the Chinkaras, but at the same point of time, a lot of information has been brought in front of the legislature while they took the decision. And thereafter, the apex court, in fact, formed an expert committee. That expert committee was asked to take note of all these developments which happened, and also go ahead and conduct a survey, and thereafter submit a particular report as regards the same, whether the government has taken all the precautionary measures before deciding to reduce this particular Chinkara sanctuaries area. So the expert committee went ahead, they considered all these factors, they prepared a report, and they put it up in front of the apex court. And in fact, the court referred to that report, and it was held that all these matters, all these permits, all this controlled exploitation of mineral wealth, whichever the government were planning, it was done accordingly. And in fact, the court, in fact, felt the apex court, in fact, felt that it would not be appropriate to denotify this particular a notification which was reducing the area of the Chinkara sanctuary, because there is a balance which the apex court pretty much reiterated, that there is a requirement for ensuring a balance between the need for protection of the environment, which includes wildlife and their habitat, and the need for economic development. So this is a very impoverished and backward area, and for that there is a dire need for economic development, and mining activity will add on to that. And with all the proper environment impact assessment done, and in fact there is a question of rapid impact assessment report also, which was put forward, and Wildlife Institute of India was also involved in that process. So the expert committee did its job. In fact, it was constituted by the Ministry of Environment and Forest only, but it has also put several factors like rich area category, biodiversity point of view was also taken into consideration by Gujarat Ecology Commission. So all these factors were taken, and the court held that no, you have to balance development and environment protection. So you cannot just give weightage to one another. One should not be undermined at the same point of time, and that is how it was held in the Consumer Education and Research Society versus Union of India, also known as the Chinkara Sanctuary case. And in addition to that, there is another case called Animal and Environmental Legal Defense Fund versus Union of India, also known as the Pench National Park case. In this particular case, what happened is that the state government, in fact, the apex court declared that the state government must always consider the rights of the tribals people who were residing inside a particular protected area before taking any action. In fact, if you want to declare a particular area and acquire that area and declare it as a national park area, you have to consider the rights of the tribals. And in this case, some of the tribals who were residing inside an area which was declared as Bench National Park, in fact, that was the matter of entire dispute, and they were resettling in another area, but they were given fishing permits in the area. But the thing is that the tribal villagers who did not initially make any claim with respect to this proclamation, which was issued under Section 19 and 21 of the Wildlife Protection Act. But thereafter, they claimed that the fishing was their only source of livelihood and it was also a traditional right. So the court held that the issuance of such permits did not fall under Section 33 of the Wildlife Protection Act, as they were issued before the final notification, and the state government was directed to issue a final notification under section 35 subsection 4 with a sense of urgency in the matter, which was in fact enjoined by article 48A of the constitution. And the court also further directed the state government to take urgent steps to prevent any destruction and damage to the environment, flora, fauna, and wildlife of that notified area. So I insist, in addition to Section 18, Section 19, and 21, please do also refer to Section 33 and 35 of the Wildlife Protection Act. So because all these sections and all these relevant provisions were pretty much noted, taken into consideration by several courts and across the timeline of recent history of wildlife related cases in India. So, in addition to that, as I was saying in the initial part of this lecture, the concept of conservation area and community reserve, sorry, conservation reserve and community reserve was also under the radar of the drafters of the Wildlife Protection Act and thereafter the amendments. So, that's why it was in fact invoked. And if you refer to Section 36 to 36B, which was incorporated by an amendment, in 2003. In fact, the state government made it very clear that after consultation with the local community only, it can declare any area owned by the government, particularly the areas adjacent to the national parks or the sanctuary or any of those areas, as a protected area. And this is also known as so-called conservation reserve. So these areas are known as conservation reserves because they are basically there to protect the landscape, the flora and the fauna of their habitats, of the wildlife. So in addition to that, the concept of community reserve also came into reality with the incorporation of Section 36C to Section 36D. So from 36C to 36D, in fact, the Godavarman case also referred to that, which where the state government is further empowered to declare a particular area as community area, where a community or an individual has volunteered a land to conserve wildlife and its habitat, and such private or community land is not comprised within national park or sanctuary or any conservation reserve. So those which are not coming under a national park, wildlife sanctuary, or conservation reserve, and a particular area or community belonging to a particular community or an individual decided voluntarily to use that land for the conservation of wildlife and their habitat, they can do so. And for that, Section 36C to 36D will be applicable, and that area will be tagged as community reserve. And this is also going in tandem with the Integrated Development of Wildlife Habitat Scheme of 2009, which was also referred in the T.N. Godavarman Thirumalpar versus Union of India's case. Now, in addition to that, there are, when it comes to the environment-related crimes, one of the major sources of so-called, money which these wildlife crimes derives comes from the wildlife animal articles and the trophies. So you have this CITES which is already there, but when it comes to our country, the central government, they have authorized to constitute Endangered Species Crime Control Bureau, and this was done with the incorporation of Chapter 4C of the Wildlife Protection Act, and this was incorporated in 2006 only. If you refer to Section 38Y to 38Z, there you will find 38Y to 38Z, Chapter 4C of the Wildlife Protection Amendment Act 2006. You will find that central government, they have created this Tiger and Other Endangered Species Crime Control Bureau, and this bureau had the power to collect all the information, intelligence informations also relating to organized wildlife crimes, apprehend the criminals, arrest them, and thereafter take necessary actions from time to time. It also advises the government of India for issuing several rules and regulations from time to time relating to wildlife crimes, which has certain national as well as international ramifications. Now, when it comes to this trade or commerce in this of animal articles, trophies, they are absolutely prohibited under the Wildlife Protection Act. In fact, it was also held in several case laws. If you refer to the Indian Handicrafts Emporium versus Union of India, there you will also come across the 2003 case. And if you refer to the Wildlife Protection Act, it clearly declared that every wild animal other than vermins, which is hunted with the permission of the wildlife warden or kept in bred in captivity or hunted in contravention of this act or rules, etc. Now, these are things which are, or maybe in fact, if you kill it by mistake, and the animal articles or the animal trophy or uncured trophy or the meat derived from that particular wild animal or ivory tusk, which we have seen been kind of exported to other countries. And whatever vehicle, vessel, weapon, trap, tool that you're using for committing an offense, all has been covered under this particular act. And whatever you seize, whenever the Bureau or the Wildlife Authority sees that, shall be the property of the state government and the central government. And if the place of hunting falls within the respective jurisdictions which comes under the protected areas, it will definitely be taken into consideration. Now, if a person obtains any possession of an animal or any animal article which has been mentioned under the Wildlife Protection Act, the first and foremost thing that individual needs to do is he must inform the nearest police station within 48 hours of obtaining such possession. And it has also been mentioned that no person who gets the so-called animal articles can keep them, acquire them in possession and custody or control. They cannot even transfer them by being of gifts or sale or otherwise. And if you want to do that, they have to do it only with the permission of the chief wildlife warden, and that has also been clearly enshrined under section 39 of, to be very specific, section 39 subsection 3 of the same. So this is something which is also relevant because there is one case by Honorable Supreme Court, that is the Wildlife Rescue and Rehabilitation Center versus Union of India case. In this particular case, it was ruled by the apex court that a large number of elephants which were owned by a particular individual and temples, it must not meet the cruel treatment. That is something which was, because many a times these elephants, they are treated very cruelly. So all these elephants must be registered, and the owners, they have to obtain a requisite certificates under section 42 of the Wildlife Protection Act, and they do also have to maintain one elephant data book. And elephants must be treated with all due respect, and they will be, even if you're using it for congregations or festivals or whatever it is, they must be treated well, they must be treated properly. And all these elephant owners, they have to comply, they have to get the certificate of ownership, but it cannot be transferred also. This is something which was also clearly held in this case of Wildlife Rescue and Rehabilitation Center versus Union of India. Now, in addition to that, there are several other provisions which you should also refer to, like, for example, Chapter 5A of the Wildlife Protection Act, which is from Section 49A to 49C. Basically, this has been also incorporated way back at an amendment in 1991. It also prohibited the trade and commerce of captive animals, trophies, animal articles, etc. In fact, the meat which are derived from certain animals which are mentioned in the schedules of the Wildlife Protection Act, import of any ivory tusks in India, or any articles which is made of ivory, or even cooking, serving meat derived from scheduled animals. All these things are pretty much prohibited under the Wildlife Protection Act. And this is something which is also in consonance with the Convention on International Trade in Endangered Species of Wild Flora and Fauna, also known as the CITES. Besides that, Section 49A to 49C also introduced an amendment which in fact prohibited dealing in trophies, animal articles which is derived from scheduled animals. And if one wants to, whoever is dealing with or wants to deal with or manufacture trophies or animal articles, they have to declare the same to the Chief Wildlife Warden, and Chief Wildlife Warden will issue a certificate of ownership to that applicant with regard to that particular animal articles or item attempts whatever whichever he wants to commercially utilize, and only on the basis of only on only once the applicant gets the certificate of ownership, the holder of so-called certificate of ownership can transfer or transport such animal articles. So it's not absolutely prohibited. I would rather say it is more like regulated, and chief wildlife warden's permission is highly required for the same. So in spite of anything, all these laws which are in force, these so-called chief wildlife wardens or the directors or any officer which has been authorized by the chief wildlife warden, or even forest officer, even police officer who is below the rank of sub inspector, if that individual has a reason to believe that any person who has committed any offense under this particular crime, there is a procedure which has been clearly enshrined under the particular section 50 of the Wildlife Protection Act. So detection and protection prevention of wildlife offences is very crucial, and I insist you please refer to section 50 to 58, because if such situation happens, that individual, they must require that, with respect to section 50, these authorities, they shall require any such person to produce for inspection any captive animal, etc., wild animal, animal article. They can also even stop any vehicle or vessel which is carrying such thing. They can also seize that particular captive animal, wild animal, etc., but provided when it's a fisherman who is residing within 10 kilometers range of a national park or sanctuary, who is inadvertently entering to that particular area in a boat, in that kind of situation, that boat shall not be seized. Otherwise, all these authorities, they have the right to, they have the power, sorry, they have the power to arrest those, apprehend those individuals, stop those vehicles, seize the animals. And because that is also a lot of a challenging task for these authorities to identify, because they, when it comes to detection and prevention of the wildlife offenses, one of the major problems that we'll find, that there are a lot of inconsistencies between the authorities. Now, the authorities that you have created under the Wildlife Protection Act, there are also this assistant conservator of forests, wildlife preservation assistant director are also there. Then you have chief wildlife warden, any other forest officers, foresters are there, and on the other side you have police. So if there is a lack in so-called proper communication, then that also leads to failure in detection and prevention of wildlife. And at times these police officers, they are also not clear about their, because many a times the chief wildlife warden, they wonder whether the Wildlife Protection Act supersedes the, because there's special legislation, and then you have a procedural laws, then you have criminal procedural code and the Indian Penal Code. But Wildlife Protection Act, on the other hand, it's a special legislation. So this is one of the major hiccups which usually they face in the very grassroots level, in the these are the real time challenges which happens over here. Now, in fact, any officer who is not below the rank of assistant director of wildlife preservation, or any officer who is not below the rank of assistant conservator of forest, that officer is authorized by the state government to, that officer has a power to search, issue warrant. That power, they have also to enforce, the power to enforce attendance of a witness, compel production of documents, record evidence. All those powers of the civil courts, they have the same. These have all these powers. In fact, any evidence which is recorded and mentioned, they shall be admissible, in fact, in a subsequent trial before a magistrate. So this is something which is very crucial with respect to the Wildlife Protection Act, and for that, the challenge is still there, and that is something which is required when you deal with such organized wildlife related crimes. You have to work in communication with the other enforcement agencies who have certain powers to arrest and investigate with respect to wildlife crimes, and that is something which is also there. Now, with respect to this Wildlife Protection Act, there are several other powers also which are there with these authorities. Now, for example, when it comes to power to investigate, well, I have already mentioned this wider power which has been given to this assistant director of wildlife preservation and an assistant conservator of the forest, and it has been authorized by the state government only. And for that, please do refer to section 50, subsection 8, and subsection 9, because this were amended in 2002 with the incorporation of wildlife, with the enactment of Wildlife Protection Amendment Act of 2002. When it comes to penalties, the Wildlife Protection Act under Section 51 and, of course, subsequent amendment of 51A incorporates several provisions relating to penalty. In fact, there is a cursory study of penalties which was provided in that act, and it was revealed that the no, the concept of no fault liability, which I believe we have already studied under Motor Vehicles Act, right? So this no fault liability was also introduced, and mens rea is not in fact required to be proved to punish a particular individual who is involved in wildlife offences. And furthermore, it was also noted that some of these offences, which has the minimum punishment, have also been provided under Section 51 of the Wildlife Protection Act. So please do refer to Section 51, which in fact clearly highlights, and you have to also read it along with Section 38J. So 38J should also be referred when you refer to Section 51. Section 51, 38J, and along with that, please do read section 360 of the CRPC, as well as this is something which is quite relevant, as well as refer to Prevention of Offenders Act 1958. So when you refer to the penalties under the Wildlife Protection Act, please to refer to section 51. Along with that, read section 38J and section 360 of CRPC. In addition to that, there was another amendment which in fact incorporated section 51A of Wildlife Protection Amendment Act of 2002. In fact, that also provide that if an individual is accused of committing any offense which is relating to Schedule 1 or Part 1 of Schedule 2 of any offense relating to hunting inside a boundary of national park or wildlife sanctuary, or altering the boundaries, etc., etc., there is certain procedure which has been clearly mentioned, and there is also reference of criminal procedure code as regards the same, and the the power of release, the right to release on bail is also been clearly mentioned, and there are certain powers also which has been enshrined. The penalties and the functions, the penalties as mentioned under section 51 of the Wildlife Protection Act clearly goes with a very long duration. In fact, it ranges. In fact, you will find that, for example, if any person who is found contravening the particular provision, Section 38J or Chapter 5A, and Chapter 5A of the Wildlife Protection Act, which is with respect to, or covered any such act, committed any breach of any conditions which has been laid down in the license or the permit granted by the Chief Wildlife Warden. In such kind of situation, the penalty for the same is imprisonment for a term which may extend to 3 years or with fine, and it may also extend to 25,000 rupees or both, right? And in addition to that, if there is a subsequent or second offense of such nature, this kind of ranges from 3 years to 7 years, and the amount is somewhere around 25,000. And if it is kind of with respect to any animals or animal article or trophy which kind of been used during this commission of the offense, the state government has the power to also seize that, forfeit that particular item which has been used for the same. So this is something which requires a bit of self-study at the same point of time. So please do refer to section 51 of the Wildlife Protection Act. Along with that, please do refer to section 38J and 360 of the CRPC. Along with that, you will come across all these things. Court, in fact, they have also certain cognizance power to take cognizance. The court shall also take cognizance of offense under this act, and that can be done if a complaint has been filed, say, by the director of the wildlife preservation, or for example, there is something called Central Zoo Authority or Tiger Conservation Authority, which came much later in 2002. So a member secretary of Central Zoo Authority can also file a complaint, and the court can take cognizance of the same. The chief wildlife warden, of course, any officer in charge in the zoo with respect to a particular violation under section 33J of the Wildlife Protection Act, or any other person who has given a notice of not less than 60 days in prescribed manner of the alleged offense, and his intention should be made very clear to the central government and state government and the other officer authorized by the same. So this is the court power to take cognizance. Now, in addition to that, I would also like to highlight this zoo authority, because that came later. It was not there in the inception of the Wildlife Protection Act, but Central Zoo Authority was created later by inclusion of Chapter 4A, if you refer to section 38A to 38 In fact, this is something which is quite significant because Section 38A onwards, you will find it deals with the constitution of Central Zoo Authority, and 38A is there, and 38B also is quite relevant with respect to that, because there you will come across the central government's power to constitute a Central Zoo Authority, which comprises of around 10 members. There will be a chairperson, a member secretary. They have around, I think, 3 years time period, and they are responsible for laying down minimum standards for all these zoos, veterinary care, etc., etc., for all those animals who are kept in zoos, evaluate and assess the functioning of zoos from time to time, recognizing, de-recognizing zoos, identifying any endangered species, ensuring maintenance of these endangered species which are in captivity, identifying any priorities and the themes with respect to display of any captive animals, coordinating training of zoo personnel, providing technical assistance, etc., etc. So these are the powers and functions. Now, in addition to that, there is something called National Tiger Conservation Authority, which was also established under the Wildlife Protection Amendment Act of 2006, keeping in mind the value of tiger, because it's an endangered species. In fact, this Tiger Conservation Foundation, which kind of has made the national authority, this National Tiger Conservation Foundation was established with an objective of protecting, preserving, and enhancing the population of tigers in India. In fact, the Union Minister of Environment is the chairperson of this National Tiger Conservation Authority, and there are several other members which has been constituted, and they have been this particular authority has been conferred several such powers with respect to powers and functions with respect to tiger conservation plan. They also are responsible for evaluating the aspects of sustainable ecology and several other aspects relating to tiger conservation, which also includes tourism activities. And state governments are also involved. They can also recommend to the National Tiger Conservation Authority from time to time to notify a particular area as a tiger reserve or a plan for tiger conservation from time to time. So this is something which, in fact, in the same line, the state government can also establish tiger conservation foundation in order to support and facilitate the management of tiger reserves in their respective jurisdiction. So this is something which is also there with respect to that. And I've already mentioned the central government have also authorized to constitute something called Tiger and Other Endangered Species Crime Control Bureau, and that is the bureau which is also working very closely with other international agencies at the same point of time to combat the issues relating to trade and commerce in wildlife. So these are the laws which are there, in fact, with respect to, I mean, these are the provisions which are there in the Wildlife Protection Act with respect to several avenues of challenges. In fact, I would rather say with respect to protecting the wildlife, and at the same point of time, there are also rights of tribals which are involved. There are also issues of developmental projects which are involved, and from time to time we have seen how judicial interpretation has enabled the decision makers and also helped the tribals to get their rights properly recognized from time to time. So this is what you will find with respect to Wildlife Protection Act of our country, and from time to time you will find that several such amendments, if you follow from 96, from 72, then 96, then 2002, 2006, these are the major amendments where all these special authorities, special agencies have been created from time to time to ensure enforcement of this particular enactment. And we have also seen the challenges that are there with respect to the procedural challenges with respect to cognizance of offense and the detection and preservation detection and prevention of wildlife crimes. And this is a challenge which is still ongoing, and there are several literature available out there where you can come across, where you will find several issues relating to such challenges in the very procedural level, and enforcement agencies, how they are facing these challenges, clash of these agencies, their jurisdictions, etc., etc. But from time to time, we have seen the courts have also taken cognizance and taken note of such clashes and try to address these challenges. So please do refer to Wildlife Protection Act of 1972 and the subsequent amendments, and the case laws. Whatever the case laws that I have mentioned in this lecture, they are very much inclusive in nature. They are not exclusive, so you have to or you can also refer to other case laws which are there and several literature available. So this is all with the Wildlife Protection Act. I hope you have followed it. It's pretty lengthy, I understand, and I have tried to bring it under one video session. So I insist you read the book and you read the legislation. Start with the special legislation. It will help you to understand better. I know this is a time of, in this time of global pandemic, we are all facing certain challenges, and this online platform is something which is available for us so that we can keep ourselves on, and we can continue with our academic discourse without jeopardizing and hampering our academic discourse. But a lot depends upon you guys also to refer to the materials which whatever I'm discussing here, and in addition to that, whatever you have. And I'll also send across some of the materials which is there with me, but I insist you follow my lecture and also read by yourself. And if you want any other materials in specific with respect to any area that you are unable to find, I'll try my best to get to you. You can email it to me. But I'm trying my best because I do also have very limited access at the same point of time. So, and I'm also not having the research database access. I completely understand, but I have my collections, so I can render my support. So this is all about Wildlife Protection Act. So I hope you're all hale and hearty. So stay safe, stay home, and take care of your family. Thank you very much. In the next class, we'll discuss some other facets of environmental law. Thank you very much.